Okay, let's unpack this. Welcome to the deep dive. We're jumping straight into a specific, high-stakes legal development that's unfolded within a larger, widely watched lawsuit.
That's right.
Our focus today is on a motion recently filed by an organization called Sanctuaries for Families. They're asking the court for permission to submit something known as an amicus curiae brief.
Exactly. And the source material you've shared with us gives us a direct look at this, filing the motion itself, the proposed brief, and crucially, analysis and perspective on the legal strategy and the potential fallout. It's a pivotal moment.
It really seems like it. It highlights a really significant legal battleground.
Mm-hmm.
Absolutely. So our mission in this deep dive is singular and focused. We're going to break down exactly what this amicus brief is all about in this specific context, understand the precise legal arguments being made, particularly defending a key California law.
Right, that's Section 47.1.
Section 47.1, exactly, and explore the significant potential implications discussed in the sources. And just to reiterate, we are sticking strictly to the information and analysis contained within the documents you've provided.
It's a fascinating snapshot, really. A specific legal tactic and the intense reactions it has provoked, all laid out in the material.
So let's dive in. First, let's get clear on the basics, as they're explained in the sources. What exactly is an amicus curiae brief, and why would Sanctuaries for Families be filing one here?
Well, amicus curiae literally means friend of the court.
Yeah.
Right. And the sources explain its role pretty clearly. It's a brief filed by someone who is not a direct party to the lawsuit, so not the plaintiff or the defendant.
Okay.
Their purpose is to sort of assist the court. They offer information, maybe expertise or insight that the court might not otherwise have, but which is relevant to the issues in the case.
So they have a strong interest in the outcome, maybe because it could set a precedent that affects their work or mission.
Precisely. But they aren't fighting in the fight themselves. They're, informing the referee, so to speak, offering perspective.
Okay, so they're not part of the immediate legal battle, but they have a stake in how it's decided because the legal principles at play matter to them. And in this situation, it's not just an amicus brief, it's a motion to file one. What's the significance of that step?
Yeah, that's important. It means Sanctuaries for Families isn't automatically allowed to just submit their brief. They have to formally ask the court for permission first.
Okay.
They file this motion explaining who they are, why they have a legitimate interest in the case, and crucially, why their brief would be helpful and relevant to the judge's decision-making.
So the judge gets to decide.
Exactly. The judge reviews the motion and decides whether to grant them leave permission to file the actual brief. It's an extra layer of court approval required.
Got it. And the organization leading this effort, according to the sources, is Sanctuaries for Families. What do the sources tell us about them and this particular filing?
The material identifies Sanctuaries for Families as the main filer. But what's really notable, and the sources point this out, is the impressive list of amitately, that's the plural form, right, who are joining this specific brief.
That's not just one group.
No, not at all. It's a coalition, a bunch of individuals and organizations lending their name and support to the arguments being made. The sources also mention a specific drafting law firm is involved, which indicates this is a pretty sophisticated and coordinated legal effort.
Right. It signals this isn't some fringe argument. It represents a significant body of interested parties.
Definitely carries weight.
An impressive coalition indeed. And what is the specific purpose of this particular amicus brief in this case? What legal point are they trying to influence?
According to the source material, the brief is filed in support of one of the motions to dismiss, in the case specifically, Blake Lively's motion to dismiss certain claims brought against her.
Okay.
But the primary purpose, the real focus highlighted in the sources, is very targeted. To defend the constitutionality of a specific California law, Civil Code Section 47.1.
Section 47.1. Okay, that law seems absolutely central to the legal strategy and the counter strategy here. The sources suggest this filing, coming from this coalition, is quite significant. One phrase that stuck out was that it puts the judge, Judge Lyman, on major notice.
Yeah, that phrase definitely jumped out. It implies this isn't just another piece of paper landing on the judge's desk,
Right.
When a group of reputable organizations, especially ones with relevant expertise or a strong public interest mission, files an amicus brief supporting a specific legal argument, like defending a statute's constitutionality, it signals to the court that the issue is important beyond just the immediate parties involved.
It suggests the decision could have wider implications.
Exactly. And that there's a substantial body of expertise and interest supporting a particular view of the law's validity. It kind of elevates the significance of that legal question for the judge.
It makes sense. It's like a powerful signal flare saying, Judge, pay close attention to the constitutionality of this law. It matters to us, and here's why. And the sources also explain what specifically triggered this filing now. It wasn't just proactive.
No, not out of the blue. The sources explicitly state this amicus brief was triggered by the opposing side, in the lawsuit specifically, by arguments made by counsel for Friedman Baldoni in their opposition to Lively's motion to dismiss.
What did they argue?
In that filing, they argue that California Civil Code Section 47.1 was or is unconstitutional.
So the amicus brief is a direct response. The opposing side challenged the validity of this specific law, and this coalition of organizations is stepping in to defend it.
Correct.
Asking the court to consider their arguments before ruling on the motion to dismiss that relies, in part, on that very law.
Exactly. It's a reactive legal maneuver. It's designed to counter that specific legal challenge the opposing side introduced, providing the judge with robust arguments supporting the law's constitutional legitimacy.
Okay, that sets the scene perfectly. Now, let's turn our attention to the law at the very heart of it, California Civil Code Section 47.1. What exactly is this law, and why has it become such a battleground, based on the sources?
Right, Section 47.1. According to the material you provided, it's described as a protective law. Its core purpose is to shield survivors or victims from what the sources call retaliatory defamation claims.
Retaliatory defamation claims. Can you unpack that a little as the sources describe it?
Absolutely. It addresses a specific problem, right? When someone, often a survivor of abuse or harm, speaks out about their experience, maybe reports it, or participates in legal or official processes, the subject of their statements, the alleged perpetrator or related parties, might turn around and file a lawsuit against them, usually for defamation.
Okay.
But this lawsuit isn't necessarily about genuinely clearing their name. It's often a tactic, sometimes called a SLAP suit, strategic lawsuit against public participation, specifically intended to silence, harass, and financially drain the survivor as retaliation for their speech or actions.
So Section 47.1 is designed to provide a legal defense against those specific types of retaliatory claims.
That's the idea. And a crucial feature of this law, highlighted in the sources, is related to costs and damages.
Ah, yes. This is the part that seems to be causing the most friction.
Yes, this is where the rubber meets the road, according to the sources. Section 47.1 includes a provision that allows for treble cost damages for a defendant who successfully prevails on the defamation claims that fall into the scope of this law.
Treble costs and damages, so 3 times the amount. Wow, that's a significant financial consequence for someone who files such a claim and loses.
It is, yeah. And it's intended as a powerful deterrent. If a defendant, like the person protected by 47.1, wins a defamation claim covered by this statute, they can potentially recover triple their legal costs and maybe certain damages they incurred fighting that claim.
So the goal is to make filing these kinds of retaliatory lawsuits financially prohibitive.
Exactly. To protect survivors' ability to speak or report without fear of being bankrupted by a retaliatory suit.
Okay, so the law protects survivors and deters retaliatory lawsuits with this significant financial penalty. But the opposing side is arguing it's unconstitutional. What's their specific legal argument against 47.1, as detailed in the source material?
Well, the sources lay out the opposing side's argument from Friedman Wayfarer pretty clearly. They contend that the treble cost damages provision in 47.1 is an overly onerous deterrent.
Overly onerous? How so?
Their legal theory, as presented in the sources, is that this severe financial penalty effectively chills their ability to exercise their First Amendment right to petition the government.
Which includes the right to file lawsuits, right? Access to the court.
Right. They argue the potential cost provision makes the risk of pursuing their defamation claims unconstitutionally high. It basically stops them from going to court.
So they're claiming the law's penalty for losing on a claim it covers is so harsh it prevents them from even filing or pursuing that claim in the first place, thereby infringing on a constitutional right. And the sources mention they're leveraging something called the Nowhere-Pennington doctrine in this argument.
Yes, that's presented as a key component of their constitutional challenge. Now, the sources describe the Nowhere-Pennington doctrine as a legal principle that actually comes from antitrust law.
Antitrust. That seems different.
It is. It generally holds that individuals or companies can petition the government, including through lawsuits or lobbying, without facing liability under antitrust laws, even if that petitioning harms competitors.
Okay.
The exception is if the petitioning is a sham, basically, not a genuine effort to get a favorable legal or political outcome, but just intended to harm a competitor by, say, tying them up in costly, baseless litigation.
Okay, so Nowhere-Pennington typically protects corporations from antitrust lawsuits when they engage with the government, even if that hurts competitors, unless it's a total sham.
Precisely. It's about protecting the right to petition from being sort of weaponized by antitrust claims. Now, the sources offer a very strong analysis of the opposing side's attempt to apply this doctrine here.
What do they say?
They describe applying Nowhere-Pennington, which, remember, was developed for corporations in a very specific context of antitrust litigation and market competition to individuals in a defamation case against a survivor as a radical argument.
Radical? Why use such strong language?
Well, the sources seem to view it as radical because it's taking a doctrine designed for corporate economic issues and trying to apply it to protect individuals from the consequences of filing a defamation claim that a state statute deems retaliatory against a protected person.
The context is completely different.
Fundamentally different. The nature of the activity petitioning is the same, but the context, the parties, the harm being regulated is just worlds apart from antitrust. The sources called this attempt a weird, weak argument, suggesting the stretching of Noah Pennington is probably not legally sound and unlikely to persuade the court. They even mentioned concerns about how it might fare on appeal, particularly in the Second Circuit.
That distinction is critical. It's not just applying a legal concept, it's importing one from a totally different legal universe. And the sources point out a historical irony here, connecting Noah Pennington to laws like 47.1.
Yeah, this is where the sources' analysis gets particularly sharp. They note that the Noah Pennington doctrine was actually an inspiration for modern anti-cell APP laws.
You mentioned cell APP laws earlier, strategic lawsuits against public participation.
Exactly. Laws designed to protect people from those retaliatory lawsuits, meant to silence their speech on matters of public concern. The sources explain that 47.1 is explicitly akin to an anti-cell APP law, but specifically tailored to address retaliatory defamation claims against survivors.
Wow. Okay, so the legal doctrine that helped inspire the whole idea of anti-cell APP protections against using lawsuits to silence people is now being used by the opposing side to argue that a law providing exactly that kind of protection is unconstitutional because its penalty is too severe.
That's the counterintuitive situation, yeah.
That does seem incredibly ironic and highlights the strained nature of their argument as the sources frame it.
That's precisely the irony highlighted in the source material. They're essentially trying to use the philosophical root of a protective legal concept to argue against the validity of one of his modern statutory embodiments.
But the sources do add a caveat.
Yes, they're careful to acknowledge that while the Noah Pennington extension might be weak, the opposing side could technically still make other, more standard First Amendment right to petition arguments against the law's penalty provision, even if the Noah Pennington specific angle is viewed as problematic.
Okay, that clarifies the challenge to 47.1 and the specific legal argument used. Now, let's turn to the defense of the law, which is the whole point of this amicus brief from Sanctuaries for Families and the Coalition. How are they supporting the constitutionality of 47.1?
The brief, as described in the sources, mounts a strong defense, arguing it is both constitutional and necessary. The sources specifically name organizations like Child USA and mention a brief filed by Elise Dorsey as examples of other amici who've also weighed in, strongly supporting the law's constitutionality in this case.
And what are the core counter-arguments presented by these amici, or discussed in the sources, to dismantle the opposing side's constitutional challenge?
The sources detail several key points. Firstly, the material notes that the law's constitutionality was explicitly considered and vetted during the legislative process when it was enacted in California.
So it wasn't just rushed through, it went through checks and balances.
That's the implication. Secondly, the sources emphasize a fundamental principle of legal due process. Laws apply uniformly to all citizens who fall under their scope, based on the criteria defined in the law itself.
Meaning who the parties are shouldn't matter. Their fame, their wealth, their public profile.
According to the sources and the arguments defending 47.1, exactly. The personal characteristics of the opposing side, whether they are rich, famous, or have a big public platform, are presented as irrelevant to whether the law constitutionally applies to their defamation claims.
It applies based on the claim, not the person.
Right. The law is written to apply to claims of a certain nature, filed against individuals in a protected category, regardless of the personal status of either party involved.
This directly addresses a point raised elsewhere and noted in the sources that this particular case is an awful first test for 47.1, because of the opponent's public profile, perceived power, or even how disliked she might be by some.
Yes, the sources specifically mention that argument being made by some individuals that because of the opponent's public persona, how disliked she is and how powerful rich she is, this case is somehow an inappropriate test case for 47.1. Implying maybe the law should only apply to less prominent individuals who supposedly can't afford counsel.
And how do the sources refute that perspective? What's the counter?
The sources firmly push back against this. They reinforce that principle of uniform application. They state that if the California legislature had intended 47.1 to only protect those without financial means, it would have included a means test provision requiring proof of financial need.
Which it doesn't have.
No. And the sources add that such a means test would likely face its own significant legal challenges, potentially on grounds of discrimination. The law, as written, applies based on the nature of the claim and the status of the defendant as a survivor, bringing a protected claim, not on their bank balance or celebrity status.
So the amici are saying applying the law uniformly is a constitutional requirement, not an option.
That's the strong stance presented in the source material. The focus, legally speaking, must remain on whether the defamation claims meet the criteria for protection under 47.1, regardless of who is filing them or against whom.
It's fascinating how the strict application of legal principles can clash with the narratives that sometimes dominate public discussion around high-profile cases. Okay, let's shift gears and look beyond the specific legal arguments about 47.1 to some of the broader strategic maneuvers and implications of this case, as analyzed in the sources.
Yeah, the sources offer some quite candid observations here. They point out a perceived gulf between actual law,
Mm-hmm.
The rigorous application of statutes, precedents, procedure in court, and what one source refers to as social media law.
Social media law. That sounds like a commentary on public opinion versus legal reality.
It does. It seems to describe a strategy or environment where public narrative, online commentary, and maybe pressure tactics on social media are prioritized, sometimes seemingly over sound legal strategy or courtroom realities. The sources contain a sharp critique, suggesting the opposing side's approach has relied heavily on cultivating what's called an army of ill-informed clowns online. Now, that phrase is colorful. But it suggests a view that the online support base maybe lacks a deep understanding of the legal intricacies, but is leveraged for public pressure, potentially to the detriment of the actual legal case.
That's a very pointed observation from the source material. And the sources also touch on perceived conspiracy theories circulating among some supporters of the opposing side.
Yes, there's a mention of theories suggesting that Blake Lively and Ryan Reynolds wield immense power, like they own not just Hollywood, but also several organizations and even the law firms involved in the case against them.
An extraordinary level of alleged control, like puppet masters.
That's the theory described. Right. But the sources immediately highlight the inherent contradiction within this narrative.
Which is?
If Lively and Reynolds truly possessed such absolute power, allegedly controlling organizations and legal processes, why, the sources ask, couldn't they simply have prevented the movie project from being taken in the first place? Why would this entire messy public legal battle even be necessary?
Right. If you own everything, why the public fight?
Exactly. The sources view this contradiction as undermining the credibility of these particular conspiracy theories, suggesting they just don't align with the actual events and legal strategies playing out.
It sounds like the sources perceive a significant disconnect between the online narratives and the practical realities of the legal fight. And speaking of the legal fight, the sources are quite critical of the opposing side's overall legal strategy, aren't they?
They are, yeah. The analysis in the source material is very critical. The decision to challenge the constitutionality of Section 47.1 and to make defamation claims such a central pillar of their case is viewed as a significant error.
Why is it seen as such a major misstep? What was the alternative?
Well, the sources suggest that crucial decisions about these legal strategies, like really evaluating the strength of defamation claims against a public figure, understanding the potential impact of laws like 47.1 should have been thoroughly considered early in the case.
The implication being they weren't properly assessed up front.
That seems to be the view. Furthermore, the sources suggest that the opposing lawyer, Brian Friedman, might have underestimated Lively's resolve, specifically her willingness to withstand public scrutiny and be dragged through the mud, as one source puts it.
So the opponent wasn't intimidated or pressured by the public attention the case generated, which perhaps was an expected outcome of a strategy that relies heavily on public narrative and pressure.
That seems to be the source's analysis. They link this to the lawyer's perceived strengths and weaknesses. They note that while this lawyer is seen as skilled at slinging mud and securing confidential settlements or arbitration outcomes,
where public pressure might work better.
Right. Situations where public attention might be a lever for a quiet resolution, he doesn't have many courtroom wins in public trials. The suggestion is that the strategy, maybe geared towards forcing a settlement through public pressure and aggressive tactics, was misapplied against a defendant who was prepared to fight openly and just wasn't susceptible to that particular form of leverage.
So the tactics that might succeed in pushing for a quiet settlement backfired in this context. It made things worse.
That's how the sources analyze it. They explicitly call the use of social media retaliation a monumental error, arguing it actually harmed the opposing side's leverage. Once you've launched a big public campaign and your opponent hasn't folded, you've kind of spent that particular tool without getting the result you wanted.
Leaving you with less room to negotiate, perhaps.
Essentially. And the sources suggest that this focus on public conflict indicates something about the opposing side's motivation.
What's that?
Yes, there's a strong assertion in the material that the opposing side's actions and statements, like reportedly declaring an intent to sue Lively into oblivion, demonstrate more interest in punishing their opponent, Blake Lively, than in genuinely pursuing viable legal claims or seeking a just outcome based on the merits.
Retribution over legal victory.
That's how the sources frame it. The focus seems to be on retribution.
And the behavior of their online supporters is also commented on.
The sources mention that the reported harassment campaign carried out by some within the opposing side's support network makes them look unhinged. Now, while this might not directly impact the legal arguments in court, it certainly affects the public perception of the case and the parties involved.
Yeah, it complicates that interplay between the legal battle and the court of public opinion.
Definitely.
It's clear the sources view the strategic decisions made, particularly around public engagement, and the focus on defamation and 47.1 as having significant consequences. Let's talk about the potential financial ones, because the sources discuss substantial financial stakes if the case continues or if certain claims are lost.
Oh, yeah. The potential financial exposure for the opposing side is described as enormous based on the source material. As we touched on, California Civil Code Section 47.1 allows for treble damages and potentially even punitive damages if Blake Lively prevails on the defamation claims that fall under that law's scope.
Treble damages and potentially punitive damages on top. That could indeed be financially crippling.
It could reach extremely high figures. The sources reference estimates from a separate report focusing on Blake Brown damages, which seems to be a reference to calculated economic losses. That report reportedly put the estimate of Lively's economic losses alone near $100 million.
Wow, $100 million, just economic losses, before considering lost work.
That's the figure cited in the sources as the estimated economic component, not including potentially lost movie work. Then the sources explain the potential impact of 47.1's treble damages provision, applying that triple multiplier to that kind of baseline. Well, it could theoretically lead to figures of $450 million or even more.
Good grief.
Now, the sources are careful to state these are estimates, ballpark figures circulating, not a court judgment. But they use them to illustrate the scale of the potential financial liability the opposing side could face, specifically because of the 47.1 penalty tied to the defamation claims.
So if Lively prevails on the defamation claims covered by 47.1, the financial hit isn't just standard legal costs. It could potentially be hundreds of millions of dollars. And the costs wouldn't necessarily end there, right? There are appeals.
Exactly. The sources mention the likely cost and duration of appeals if the case were to proceed. They note the possibility of it going all the way up to SCOTUS, the Supreme Court of the United States.
Which costs a fortune.
Right. Litigation at that level and the preceding appeals courts is incredibly expensive. Costs a pretty penny, as the sources phrase it. So the financial risk includes not just the potential for massive damages under 47.1, but also the substantial ongoing legal fees just to pursue appeals through the highest courts.
Given these incredibly high financial stakes and the critical analysis of the legal strategy presented in the sources, they also explore potential ways for the opposing side to navigate this specific predicament. Related to the defamation claims, the challenge to 47.1, and the involvement of the Amici. What are the reasonable ways out discussed?
The sources analyze two primary potential strategies for the opposing side to maybe mitigate the risks they currently face, particularly concerning the defamation claims and the whole 47.1 issue.
Okay, let's look at option A. What's that?
Option A, as discussed, is for the opposing side to submit a letter to the court explicitly stating they are no longer challenging the constitutionality of California Civil Code, Section 47.1.
Just drop the constitutional challenge. And what does the source material say about the effect and framing of that move?
Well, the sources suggest this would signal a retreat from that specific constitutional fight, which was a key trigger for the Amicus briefs.
Right.
However, it likely wouldn't make the Amici just disappear entirely.
Why not?
Because the Amici filed not just because the law's constitutionality was challenged, but also because they want the court to actually apply and rely on 47.1 when ruling on Lively's motion to dismiss the defamation claims.
Oh, they want the precedent.
Exactly. Such a ruling in their favor would establish valuable precedent for applying 47.1 in future cases involving similar retaliatory claims against survivors. So the Amici would likely stay involved to push for the application of the law, even if the constitutional challenge is dropped.
Okay, so how could the opposing side frame that move then?
They could try to frame this withdrawal by saying, look, they respect the protective purpose and mission of 47.1, but they still believe this specific case isn't where the law should apply as a basis for dismissing their claims. Maybe because they maintain they've properly pled malice, which is that higher standard required for defamation claims involving public figures.
So argue malice means 47.1 shouldn't dismiss the claim here.
That's the potential argument. They could say if malice is properly alleged, 47.1 shouldn't function to dismiss the claim outright in this instance.
So they back down on the constitutionality but still fight the application of the law to dismiss their claims. What's option B?
Option B is a more complete exit from this particular legal minefield, withdrawing the defamation claims entirely. Just pull them.
And would that make the Amici coalition leave?
Yes. The sources indicate that withdrawing the defamation claims would achieve that. Since the Amici's primary interest is in defending 47.1 in the context of those specific claims, removing the claims themselves removes the grounds for their intervention.
Okay, and how could they frame that withdrawal publicly?
The sources discuss this. They could state that while they still believe their defamation claims are strong and would eventually win, the potential risk of facing treble cost damages under 47.1 is simply too high.
So blame the penalty, not the weakness of the claim.
Essentially. They could simultaneously express support for the law's protective purpose in deterring retaliatory claims against victims, while explaining that the financial exposure in this specific high-stakes context is just too great for them to bear.
That sounds like a way to cut their losses on the part of the case that seems to be causing the most significant legal problems and financial risk, according to the sources.
That's the assessment presented. And the sources even suggest a potential PR strategy for this withdrawal. They could announce it alongside Blake Lively's reported withdrawal of other claims, like those for intentional infliction of emotional distress, IIED. By presenting these actions together, the opposing side could try to frame it as a mutual effort by both sides to simply streamline our cases here.
Making their withdrawal seem like a strategic litigation management move rather than a forced retreat driven by legal or financial pressure.
Exactly. A way to neutralize any perceived victory for the opponent.
That's a clever way to potentially spin it publicly. Do the sources indicate which of these options, if any, is likely?
Well, while the sources express a hope that the opposing side will choose option B, withdrawing the defamation claims entirely as a way to simplify the case and remove the heated battle over 47.1, they explicitly state they believe this outcome is unlikely.
Okay. But let's pursue that thread for a moment. If they did withdraw the defamation claims, would the treble damages provision of 47.1 still apply? The sources discuss this, linking it to the concept of a safe harbor letter. What's that?
Right, the safe harbor letter. It's a formal warning required under Rule 11 of the Federal Rules of Civil Procedure before a party can ask the court for sanctions against an opponent for filing frivolous claims.
Okay.
The letter basically gives the party who filed the questionable claim a chance, usually 21 days, to withdraw it before the other side files a motion for sanctions. It's a chance to fix your mistake, essentially.
So does withdrawing during that safe harbor period avoid the 47.1 damages?
The source's analysis is that, generally speaking, if the defamation claims are voluntarily withdrawn before the judge rules on any motions to dismiss, MTDs, or Rule 11 motions, the 47.1 treble damages would likely not apply.
And the reason 47.1 wouldn't apply in that scenario, why not?
Because under 47.1, you typically have to be a prevailing defendant on the claims subject to the law. If the claims are voluntarily withdrawn by the plaintiff before a court ruling, the defendant isn't technically prevailing in the sense of winning a court judgment dismissing the claims. The claims are just gone because the other side pulled them.
I see. So withdrawing before a ruling usually lets you avoid the specific treble damages under 47.1. But the sources introduce a potential wrinkle related to Rule 11 sanctions, even if the claims are withdrawn.
Yes, this is a key point in their analysis. Rule 11 sanctions are penalties the court can impose on parties or their attorneys for filing documents or claims that are factually baseless, legally frivolous, or brought for improper purposes like harassment.
Okay.
The sources speculate that Judge Lyman could potentially still rule on Rule 11 motions seeking sanctions, even if the defamation claims are withdrawn after a safe harbor letter was sent.
Why would the judge do that even after withdrawal, if the claim is gone?
Well, the sources suggest the judge might take the view that if the claims were frivolous from the start, the opposing side was still forced to spend time and money responding to them, maybe during that safe harbor period or even before the withdrawal.
Ah, the damage was already done by filing it.
Potentially. Therefore, the party who filed the allegedly frivolous claims should maybe still face a penalty regardless of withdrawing them later. In this specific scenario, the sources speculate that Lively might then be considered a prevailing defendant for Rule 11 purposes, potentially making her eligible to recover costs specifically related to fighting those allegedly frivolous filings.
Even if 47.1 damages don't apply?
Exactly. Even if 47.1 treble damages are off the table because of the withdrawal.
Okay, so withdrawal might avoid the 47.1 treble damages, but could still open the door to Rule 11 sanctions for filing the claims in the first place. And the sources differentiate between those two types of potential recovery.
They do. The sources speculate the judge might award either Rule 11 sanctions or 47.1 damages if applicable, but perhaps not both for the exact same conduct or costs. They express a view that 47.1 might not have been designed to cover the specific type of bad lawyering addressed by Rule 11 sanctions. They suggest the drafters of 47.1 were focused more specifically on deterring those retaliatory defamation claims against survivors, not necessarily penalizing generally frivolous litigation divorced from that specific retaliatory context.
Got it. But regardless of whether it's 47.1 damages if they don't withdraw and lose, or potentially Rule 11 sanctions if they do withdraw after a safe harbor letter, the sources view either outcome in a very specific light for the opponent, Blake Lively.
Correct. The source material concludes this point by stating that receiving either damages under 47.1 or sanctions under Rule 11 is considered a win for Lively.
A win how?
The sources view it as providing her with a cash infusion mid-litigation. This financial recovery would essentially help fund her continued pursuit of her own claims against the other side.
Right. The sources mentioned her claims FAA, EEOC, retaliation, conspiracy.
Exactly. Those are the claims listed in the sources as the ones she is pursuing, which would presumably continue even if the opposing side's defamation claims are dismissed or withdrawn.
So the potential financial penalties facing the opposing side could directly fuel Lively's ability to pursue her case against them. The sources seem remarkably certain about the fundamental importance of the defamation claims to the opposing side's overall lawsuit.
Yes, there's a very strong opinion articulated in the source material. The opposing side's case, referred to as the Wayfarer case, is deemed entirely unworkable without defamation at its core.
Unworkable. That's a definitive assessment. Why do the sources believe the case hinges so completely on defamation?
Well, they describe the backup plan should the main defamation claims like those reportedly against the New York Times be dismissed as tenuous.
Tenuous. What's Plan B?
This Plan B, according to the sources, involves trying to pursue defamation claims against other individuals for statements made elsewhere. For example, claims against a person named Sloan for statements allegedly made to the Daily Mail, which the source indicates are perceived as already falling apart.
Okay, anyone else?
And also claims against Ryan Reynolds related to alleged predator statements and his involvement in something referred to as Nice Pool.
And how does winning against these other individuals potentially connect back to Blake Lively, according to this backup plan? How would that work?
The idea, apparently, is to then argue vicarious liability, essentially that Blake Lively is legally responsible for the statements allegedly made by these other individuals based on their connection to her or her actions.
So the path is lose the main defamation claims, try to win defamation claims against other individuals, then argue Lively is responsible for their statements through vicarious liability.
That sounds complicated.
That's the tenuous backup strategy outlined in the source. And the sources immediately tie this back to the risk of 47.1.
How so?
They state that if these remaining defamation claims against individuals like Sloan or Reynolds also trigger the protections of Section 47.1, which they likely would if they're seen as retaliatory against Lively based on her protected activity, then in the source's analysis, the entire situation falls apart.
Because the treble damages risk comes back.
Yep.
It's exactly. The potential for facing 47.1 treble damages on these backup claims makes them too risky to pursue as a viable path forward if the main defamation claims are dismissed.
It paints a picture where the defamation claims aren't just one piece of the puzzle, but the absolute linchpin. And that linchpin is facing significant legal challenge, including the defense of 47.1 bolstered by the Amicus briefs. This leads to one final strategic point. The sources raise the potential need for new counsel for the opposing side.
Yes, the sources suggest that at some point in the litigation, the opposing side might need to seek different counsel.
And the reasoning behind that suggestion, why new lawyers?
The sources believe new counsel could have a real chat, a frank discussion, with the various parties involved in the Wayfair case about the very serious risks associated with the defamation claims, particularly in light of 47.1 and the potential financial exposure.
A reality check, maybe?
Something like that. They point out that many individuals who are plaintiffs in the Wayfair case might also be defendants themselves in other related legal actions stemming from the whole situation.
So they're fighting battles on multiple fronts, also on the defensive.
Exactly. And as defendants, their primary interest is often limiting their own liability and financial losses. The sources suggest these parties, who are primarily concerned with their defense and potential exposure, might have nothing to gain by continuing to aggressively pursue defamation claims against Lively.
Only money to lose.
Only money to lose, exactly, especially with the risk of 47.1 treble damages hanging over those claims. Their motivation might be very different from, say, an attorney solely focused on a plaintiff's aggressive offensive strategy.
So the current counsel might not be best positioned for that kind of risk assessment conversation.
The sources imply that,
Yeah.
that the current counsel might not be the best fit to have these frank conversations about risk and potential exits, especially with parties whose main priority might realistically be self-protection in a really complex web of litigation.
Wow. Okay, well, that brings us to the conclusion of this deep dive into the sources you provided. We've covered a lot of ground. The strategic significance of the amicus brief filed by Sanctuaries for Families and the Coalition.
Right, and how it supports the constitutionality of California Civil Code, Section 47.1.
We've delved into the core legal arguments surrounding 47.1, including the opposing side's challenge using the First Amendment and Noah Pennington.
And the source's pretty sharp critique of that argument, pointing out the irony.
Definitely. We've also explored the strategic landscape as analyzed in the sources, everything from the perceived tension between actual law and social media law to the strong criticism of the opposing legal strategy.
The potentially massive financial stakes illuminated by that 47.1 provision and the various potential outcomes and strategic exits discussed in the material. It's a complex and multi-layered legal situation.
It really is, and the sources offer a clear perspective on this specific battle over Section 47.1 and its potential consequences. And why is understanding all of this important for you, the listener, who brought us these sources? Because as the material shows, it's a powerful illustration of how specific laws designed to protect vulnerable individuals like survivors from retaliatory lawsuits can become central, hotly contested battlegrounds in litigation, especially when significant interests are involved.
Yeah, it really highlights how specific legal strategies, their perceived strength and weaknesses according to the sources, can play out with potentially enormous financial and legal consequences.
And it underscores that complex interaction between courtroom battles and public narratives, all viewed through the lens of the documents you shared.
Absolutely.
And the sources, in emphasizing that laws apply uniformly regardless of who you are or your public profile, raise a fundamental question. It leaves us with a thought for you to ponder. In an era saturated with online commentary, public opinion campaigns, and narratives shaped by perceived power or popularity, how effectively do the strict principles of legal interpretation and impartial application truly withstand those external pressures?
It's a vital question, isn't it? About the nature of justice in the digital age, brought into really sharp focus by the dynamics described in these sources.
This deep dive into your source material has given us a focused view of the legal arguments, strategic considerations, and potential outcomes at this critical juncture in the case. Thanks for bringing us these documents and allowing us to explore them in depth with you.
Always a privilege to dive deep into the material you share. It's fascinating stuff.